No, 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 I can't believe it. The jury gave me too much money in their verdict. I want to give back some money, said no one ever. You want to know what this is all about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now here's the scenario. You brought a medical malpractice lawsuit against your doctor claiming that he was careless and that his carelessness was a significant cause of your injury, and you suffered substantial harm and injury. And now your case goes all the way to trial. After 2 weeks of hard-fought litigation, of hard-fought trial, the jury ultimately reaches a verdict in your favor. You are thrilled, you are ecstatic. And guess what? The jury gives you millions and millions of dollars. And you are totally thrilled. Why? Because you wanted to settle this case, your attorney wanted to settle this case for a very small amount of money, for only a few $100,000 in comparison to what the jury actually gave you. And now you are so excited. Can you imagine an injured victim standing up after the jury reaches their verdict and says, "Excuse me, judge, wait, something's wrong here. The jury gave me too much money. I want to give it back. Please give it back. I don't need all this money." Do you ever think that would happen? The answer is no, it will never happen. Why not? Because the jury has made a determination that you are entitled to a verdict in your favor. The jury, after listening to all of the evidence, all the testimony, and all the witnesses, have come to the conclusion that yes, your doctor was careless. And yes, his carelessness was a cause of your injury. And yes, in fact, your injuries are significant and permanent. And the jury has determined that for each element of damages, you are entitled to a substantial amount of money to compensate you for all of those harms. And now, collectively, that amount comes to many millions of dollars. And you are shocked. You never in your wildest dreams expected the jury to come back and give you that amount of money as a value for the injuries and the harms and losses that you suffered. So now, do you think anybody would want to give that money back? No. Instead, they say, "Yes, thank you so much." So now, here's the dilemma. The dilemma is that now the jury has spoken. The jury has decided that you are entitled to receive $10 million as your damages. Well, guess what? You now have in your mind that your injuries are worth $10 million. Well, the first thing that's going to happen is the defense lawyer is going to jump up out of his seat as if somebody pressed an ejection button and yell out, "Objection, Judge! That verdict is against the weight of the evidence. I ask that you throw out the verdict." That's the very first thing the defense lawyer is going to do. And you're going to be wondering, why is he doing that? The jury just spoke. 6 members of the community just determined that my injuries are worth $10 million. Who is he to now say that I'm not entitled to anything? But that's the first thing he's going to do to try and protect his clients. Assuming that the judge says, "No, no, no, defense lawyer, I am not throwing out this verdict. I will consider reducing it, but you now have to explain to me why. Tell me why. Based on what evidence and what testimony in this case? Show me exactly." And now he'll give the defense lawyer time to get the trial transcript and to provide him with legal research to try and document and show that these injuries are wildly excessive. And in that instance, now your attorney will have an opportunity to rebut those arguments. And then the judge will have to evaluate those actual arguments. And then he'll have to make a decision. If the judge agrees with the defense lawyer, that $10 million verdict that you got is now going to be reduced. And that is a possibility. On the other hand, the judge could turn around and say, "You know what? I'm going to let the jury verdict stand. If you don't like this verdict, you can take it up on appeal to the appellate court." But that $10 million valuation, there is the possibility that the judge is not going to agree with it. The judge may look at other similar cases with other similar verdicts and say, "You know what? In those other cases, this type of injury only received $5 million. And so that's what I'm going to do in this case. I'm going to reduce the value of your award to $5 million. So let's say he does that as an example. And now you're thinking, wait a second, how could the judge do that? The jury spoke. That was the final decision, right? That's their final answer. Well, no, that's not the final decision. The final decision might possibly rest with the judge, the trial judge, but then again, it might not. What do I mean? Well, let's say the judge decides that your injuries are worth no more than $5 million. So he cuts the verdict basically in half. And he says this verdict now is consistent with other similar cases and other similar verdicts in this county. So what happens then? I guarantee you that the defense lawyer still will be unhappy with that result. So again, instead of him jumping up at this point and somebody pressing the ejection button, him yelling out, "Objection, Judge, that's still not good for me." Instead, behind the scenes in his office, he prepares papers and now goes to appeal the trial judge's decision. And what's the decision that he's appealing? He's appealing really two decisions. One, he's appealing the first jury verdict that came in that set the amount that you should be receiving of $10 million. And then he's appealing the second decision, which is the judge's decision to cut the verdict in half. He said it wasn't enough. So now he takes it up on appeal. And on appeal, there's no new trial. There's no new evidence that's presented. Instead, a panel of judges, of appellate judges, now review the trial transcript to see whether there were errors of law that were made during the course of your trial. And the appellate court has a number of different options available to it. It could, in fact, throw your verdict out as saying that it was, in fact, against the weight of the evidence. On the other hand, they could say, no, the verdict is going to stand, but we're going to reevaluate the damages. Now, that $10 million verdict? Absolutely not. That gets thrown out. The judge's verdict, $5 million? No, we don't agree with that. We think that the verdict should be lower. We think that the amount you should receive should be much lower. Let's say they decide $1 million. So now you're thinking, how could this be? The jury said $10 million. The trial judge said $5 million. And now the appellate court said the most you are to receive is $1 million. If the appellate court says, you know what, we think your injuries are only worth $1 million, now each side has to agree. And if the parties do not agree, guess what? You start your trial all over again from the very beginning. That means picking a new jury, trying the case from the very beginning, and having it done all over again. And after you go through all those weeks of litigation again, of trial, you can still wind up with the same actual result where the jury gives you an incredible verdict that then gets cut down by the trial judge and gets cut down again by the appellate court. So you can wind up going through this entire process that can ultimately take years to come to a resolution. So when I raise the topic of this video, no, Judge, that's too much money. I want to give most of it back. I don't need all this money. The reality is, no one in their right mind is ever going to say that. So why do I share this information with you? I share it with you just to give you an insight into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you probably have questions or concerns about your own matter. Well, if you have not yet started a lawsuit yet and are thinking about bringing a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.